Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court Justice, with me, Jill Barton. On this episode, I've asked our AI hosts to describe the modern style for writing titles, names, and abbreviations. These are things way too many legal writers get wrong. Let's listen in to avoid picking up bad habits and learn the modern style.
Have you ever heard of a legal case getting tossed out just because of a nickname?
Sounds pretty wild, doesn't it?
It really does, but it actually happened. A prosecutor kept calling the defendant murder, and believe it or not, the conviction was vacated.
Wow.
Yeah, it just shows you the kind of power packed into something as simple as a name, right? Even in the, super formal world of law.
Absolutely.
Yeah.
And that really underscores why we're doing this deep dive today. We're getting into the real nitty-gritty of modern legal writing style.
Specifically names, titles, abbreviations, that sort of thing.
Exactly. We want to help you write with the kind of crispness and clarity you see from, top legal minds today. And we're leaning heavily on Jill Barton's Supreme Guide to Writing as our guide here.
Right. This isn't about, dusty old grammar rules nobody follows anymore.
No, definitely not.
Our mission here is really practical. We want to give you, whether you're, just starting law school or you've been practicing for a while, some solid, actionable tips, stuff you can use right away to make your legal writing better. So we'll be pulling out the key principles from Barton's guide, and we'll even look at how the Supreme Court justices themselves handle these things in their writing.
And the foundation for all of this, according to Barton, really comes down to three things: consistency, impartiality, and conciseness.
But it's interesting, Barton also notes how using names thoughtfully can actually humanize things.
Humanize legal proceedings. How so?
Well, when the justices use actual names when they're laying out the facts of a case, it adds this layer of respect. It acknowledges the real people involved, not just abstract legal concepts.
That's a great point, and it leads right into Barton's first unanimous rule she identifies. When you're telling someone's story within a legal document, the narrative parts stick to consistent, unbiased names. Use their actual names.
Okay.
But then, when you switch gears to talk about broader legal ideas or principles, that's when you use more generic terms.
So specific names for the story, generic terms for the legal analysis.
Precisely. It keeps the focus clear. Specific when understanding the who matters, and general when explaining the what or why in law.
And this rule also hits on something really important, that potential for gender bias in how we name people professionally.
Yes. Barton points to a study that found a pretty noticeable tendency to call male professionals by their last names, but use first names for women in similar positions.
Right, which can subtly undermine women's professional standing. Justice Ginsburg talked about that, didn't she, in the United States v. Virginia case about equal citizenship stature.
She did, and the justices seem very aware of this.
Yeah.
Barton notes their practice using full names first, then just surnames for everyone involved is a clear way they sidestep that kind of bias.
Can you give an example?
Sure. Take Justice Sotomayor's writing in Wilkins v. United States. Barton points out she starts very clearly. Larry Stephen Wilkins and Jane Stanton, full names.
Okay.
Then later on, she just refers to them as Wilkins and Stanton. Smooth transition.
Okay, let's shift gears a bit. What about parentheticals for shortened names? Like putting Smith after John Smith.
Ah, yes. Our instinct might be to do that automatically, right?
Totally. Seems like standard practice.
Well, Barton points out the justices are actually much more selective. They don't just do it by default.
But when do they use them?
The rule is basically use them only when you really need them to avoid confusion. Think cases with lots of parties, or maybe really complicated names or entities.
So not for a simple petitioner Jane Cummings.
Exactly. Justice Roberts, in Cummings v. Premier Rehab Keller, is a good example. He introduces petitioner Jane Cummings, and then later just calls her Cummings. No parenthetical needed.
Simple enough.
But interestingly, in that same opinion, he does use a parenthetical for ASL after writing out American Sign Language.
Because ASL might not be universally recognized as an abbreviation.
Precisely. That's where it helps clarity. It highlights the real purpose. Use them for genuinely complex situations or less common abbreviations, not just as a habit for every name.
Got it. Any other examples of good use?
Sure. Barton mentions Justice Barrett dealing with the U.S. Fish and Wildlife Service, FWS, and National Marine Fisheries Service, NMFS. That's a mouthful.
Definitely.
So Barrett introduces them with the acronyms in parentheses and then cleverly uses another parenthetical to refer to them collectively, together services. That really streamlines the rest of the writing when dealing with multiple long agency names.
That's smart. Are there alternatives to parentheticals for abbreviations?
Yes. Chief Justice Roberts sometimes uses a different approach. Barton gives the example of Department of Homeland Security, DHS, and then, for another term, Deferred Action for Childhood Arrivals, or DACA.
So instead of just the parenthetical, he uses or DACA.
Right. Spells it out, then introduces the common abbreviation with or. Just another clear way to ensure the reader knows what the short form stands for without always defaulting to parentheses.
Okay, that makes sense. Let's talk about courtesy titles. Mr., Mrs., MX. That feels like a big area of change.
It really is. Barton highlights this as a majority rule reflecting a pretty significant modern shift, moving away from gender-based courtesy titles in written opinions.
So less Mr. Smith and Mrs. Jones in the actual written decisions.
Generally, yes. While you still see them in some traditional publications, maybe like the New York Times, the Supreme Court justices, for the most part, have dropped them in their writing.
Interesting. But not in oral arguments.
That's the exception, Barton notes. During oral arguments, those traditional forms of address, Mr. Advocate, Mrs. Advocate, are still very common. It's more about the written style.
And is this trend widespread among the justices?
Very much so. The dominant trend is definitely towards less formality in this specific way.
Is there a reason for the shift?
Well, Barton touches on the broader cultural context. You know how some countries like France, Germany, Italy moved away from certain gendered titles, partly because they could feel outdated or unnecessarily focused on marital status.
Like mademoiselle or Fräulein.
Exactly.
So the court's practice reflects that broader move towards less gender-specific language.
It seems that way. Barton observes they've largely steered clear of Miss, Mrs., even ma'am in opinions, unless they're quoting an older source where it was used originally. The modern approach favored by most justices is full name first, then just the surname.
And this idea of skipping titles, Barton says it applies even when you're, say, writing an email or letter to someone for the first time.
That's her advice. Don't guess someone's gender or preferred title. The safest, most respectful route is often just using their full name in the salutation.
Like, good morning, Whitney Dutton. But what if someone does want to use courtesy titles? Is there guidance on that?
There is. Barton offers a guiding principle. If you choose to use them, you absolutely need to be sure you know the person's gender and use the correct title. It's tricky territory.
And she mentions one justice still uses them fairly often.
Right. Justice Gorsuch is noted as the one who most consistently still employs full name on the first mention, then title plus surname later. So Irvine Davenport becomes Mr. Davenport.
You mentioned oral arguments earlier, how titles are still used there. That brings us to professional titles, right? Like judge, governor, doctor.
Exactly. While those generic courtesy titles, Mr. and Ms., are often dropped, professional titles are a different story.
We still use those.
Generally, yes. Titles like Chief Justice, Justice, Judge, President, Governor, Secretary, Senator, Professor, Dr. Barton says these are usually kept in legal writing. It's seen as a mark of respect for the person's position or expertise.
Is the usage totally uniform?
Not perfectly uniform across all opinions, Barton notes. There could be slight variations between justices, but the absolute key, again, is consistency within a single opinion. Whatever style you choose, stick with it.
Okay, so what are the main guidelines for using these professional titles?
The most common principle is use the professional title with the full name on the first reference.
Like Governor Chris Christie.
Right. And then in later references, you use just the title and the surname.
So Governor Christmas.
Exactly.
Is there a rule for really well-known people?
Yes. For individuals who are widely recognized, it's common practice, Barton says, to just use the professional title and surname from the get-go.
Like President Ford or President Eisenhower.
Correct. No need for the full name first in those cases, usually.
But are there exceptions? When might you use the full name, even for someone famous?
The main exception is when just using the title and surname could cause confusion.
Ah, like if you have presidents with the same last name.
Precisely. Barton gives the examples. You'd likely write President Theodore Roosevelt and President Franklin D. Roosevelt, to be clear. Same idea for President George W. Bush and President George H.W. Bush. Clarity trumps the shortcut there.
Makes sense. What about capitalization?
Yes. A unanimous rule, Barton points out. Always capitalize professional titles when they refer to a specific person or office, and always capitalize the names of government organizations.
So the governor of New York, the solicitor general, the president, Congress, all capitalized.
Correct. And of course, court is always capitalized when you mean the U.S. Supreme Court. It's standard formal usage for brevity and respect.
Thanks so much for joining us for this deep dive today.
We hope these insights from Barton's Guide help you feel even more confident in your writing.
So the bottom line is, skip those unnecessary parentheticals, and generally avoid gender-based titles. Tune in next time to hear how the justices finesse a point with double negatives. And remember, you can be a great legal writer.